Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today's guest is Daniel Thies. He is a partner at Weber and Thies, but he is also, for the most purposes for this conversation, the chair of the Council of the American Bar Association section of Legal Education and Admissions to the Bar. So welcome, Daniel.
Thank you for having me, Patty. It's great to be here.
Well, I'm excited because, accreditation is a hot topic, probably more so than any of us dreamed it would be 5 years ago. But start, if you would, by sharing with our listeners what prompted you to become chair of the council and exactly what is the council and what does it do?
Well, so the council is the body that's recognized by the Department of Education as the accreditor of the JD degree in the United States. And in this context, accreditation is really just a seal of approval. So like for your law school, Patty, if we go to St. Mary's, we'll be evaluating the quality of the school to make sure that it is meeting our standards and that it's providing a quality legal education. And we do that across the country. Now, some people ask sometimes, well, why is it that there's, a council that's a part of the section of the legal education and admissions to the bar of the American Bar Association? Why do you have that responsibility? And there's really two reasons for that. One is, as I mentioned, the Department of Education. We've been recognized by them since 1952 to play this role. The other is that the state Supreme Courts in each of the 50 states rely on our accreditation when they're deciding who is qualified to take the bar exam or otherwise to join the bar in their states. So it was a process over about 30 years, from the 1920s to the 1940s, where the council was demonstrating to the state Supreme Courts that we'd be valuable in that role. And so it's our accreditation that we do for them that really gives us the authority that we have. And we only have that authority as long as we're able to convince the Supreme Courts, that we're doing the right thing and that it's worth relying on us.
Well, I have been at two law schools and part of a number of ABA accreditation processes or reaccreditation. They're very thorough. You, of course, send out an annual questionnaire every year, very comprehensive, that all law schools who are accredited have to respond to. Why is it important that we do this? Why does having some kind of national accreditor matter?
The most important thing that having a national accreditor gives us is portability of the degree. So in theory, each of the states could do this themselves. But then you'd have the problem of, well, if Illinois recognizes these 10 law schools and Indiana recognizes another 6 law schools, right? What happens if somebody graduates from a law school in Indiana that's only recognized by the Indiana Supreme Court and they want to come over and practice law in Illinois? And in order to get that portability, you really need one national accreditor. So, for example, our law firm is in downstate Illinois. We're just about 35 miles from the Indiana border. And our most recent hire was a graduate of Indiana Law School. And it's the portability that having one national accreditor provides that allowed that attorney to come and join our firm, even though, in the spring of his 3L year, he didn't know where he was going to go yet. He still had that flexibility because all 50 states recognize his law school through our accreditation as making him eligible to sit for the bar. And that happens thousands of times every year all across the country as students move from law schools in one state to practice in an entirely different state.
Well, I think that's really important, especially when we have states, including my own in Texas, that have Supreme Courts issuing orders that are impacting this national accreditation by the American Bar Association section of legal education and admissions to the bar. So, I've been getting questions from applicants and alumni and current students ever since the Texas Supreme Court said that ABA accreditation would not be required for those who were going to sit for the Texas bar. And I simply tell them all, we're going to maintain our ABA accreditation. I mean, for exactly the reason that you said. We need to ensure that our graduates can take the bar in Texas, but then also take that score elsewhere. It was why I understand we moved as a state to the UBE, and it is why at least St. Mary's University School of Law will continue to have the ABA accreditation. So these are interesting times. Are you finding, I know Florida had more of a kind of a several different options that their study came up with as possible accreditation alternatives. What is the reaction you're getting from law school deans and state Supreme Courts as far as this move among a few states to a different system?
Well, thank you, Patty, first for the vote of confidence in us. I appreciate that. And actually, that is the common response that we've been hearing from deans across the country. Is so far, every single dean I've talked to has said we're going to continue to be accredited by the American Bar Association because of how important portability is to our students. So that it is not an uncommon response. I think among students, there is some confusion out there, given the orders that the Supreme Courts in Texas and Florida have put out. But the overriding message there is that although those states have invited alternatives for accreditation, we can talk about some of those if you want. But fundamentally, they both also said portability is important to us. And as of right now, we're going to continue to recognize every school accredited by the council as an accredited school in our state. So in Texas, the way this looked is that they changed their rule to say that you have to graduate from a school accredited by the Supreme Court of Texas, right, rather than by the council. They then appended a list of what those schools would be, and it is exactly the same list as what the council's list is. So in the short term, nothing changed. And students need to know that, particularly if they're graduating this spring and wondering about, can I graduate in Texas and still go to law to an employer in Arkansas or something like that? The answer is yes, you can, just as you always have. In Florida, it's basically the same story. Their order was slightly different, but they said, we are going to continue to recognize as eligible to join the bar in Florida all students who graduate from a school recognized by a Department of Education recognized accreditor, right? So, and as I said at the outset, the council is the only recognized accreditor of the JD degree. So as of right now, that means Florida is just relying on the council accreditation, again, as it always had. So that could change in the future, in theory. I actually think it's not very plausible that in the short or medium term that we'd see an alternative accreditor emerge. But Texas and Florida have basically invited others to try to do that. And so we'll see over the next few years if there's interest or appetite among the states in pursuing some sort of alternative accreditation system.
These are certainly wild times. I will say that for me, I think the deans have been very clear with the council. There are some things that we think have been overly burdensome in the reporting requirements, and some things that we've come to explore with you more to see whether, they're really things that are necessary to a reaccreditation. And, those comments have been happening at least in the 6 years that I've been dean, but I have found the council very responsive. And so maybe you can share, what do you say to the groups, whether they're deans or Supreme Court justices, that say, well, the ABA is doing much more than an accreditor would or should, how they're managing the law school accreditation process.
Mm-hmm. Well, thank you again. It is our goal to be responsive, and I will be the first to say that we're not perfect in that, and we can always improve. And I think the key to what you're describing, the importance of making sure we're not putting unnecessary burdens on schools, is communication, right? So the more that we can get out to talk to the deans, the law schools, to understand what you're going through, the better we'll be able to tailor our requirements to only, as you said, what's needed for accreditation. So we've been implementing different ways this year of trying to listen, sending more council members to the AALS meeting, for example, to meet with the deans. Also having an advisory committee appointed that's made up about half of deans and about half of Supreme Court justices, to make sure that we're hearing from those two key constituencies as we make all of our decisions. I will say also, of course, communication is a two-way street. And as we're listening, we're also wanting to explain the burdens and requirements put on the council. So sometimes those in the legal education world don't necessarily understand that some of what we require is actually passed through from what the Department of Education requires of us to be a recognized accreditor. So, the department is extremely influential, for example, in shaping our distance education standards. And I know St. Mary's is very familiar with those, as you've got one of the only fully online programs in the country demonstrating that it is possible to have one in a council accredited school, and you've done it very well. But again, you had to go through some hoops to get there, applying for what's called a substantive change, which is kind of a term of art or a buzzword in the accreditation world. And it's something that the department requires, again, that when a school wants to implement a new program like that, going to a distance format rather than in person, there's a whole set of requirements that you've got to meet, and almost all of those come from the department. So that's just one example of many of where our processes that sometimes create burdens on law schools are really imposed on us, and not something that we've got complete freedom to make the way that we'd like.
That makes a lot of sense. And I think that message is important to get out there, that DOE has their own requirements that you have have to abide by. Thank you for the comments about our online program. When we went through it, it was a very thorough process, but there was no fully online ABA approved law school or ABA accredited law school that had such a program. So I didn't mind the burdens that you put on St. Mary's to go through that process because I think it's so important for consumer protection, right? I want, if a law school or many law schools, as many have followed and are now offering their own fully online or partially online JD programs, they have gone through sometimes less strict hoops, if you will, or requirements, but only because now there are about 22 such law schools. So for having a new program like that, something that was not tried and tested yet, I'm glad that the ABA was as thorough as it was. So that makes a lot of sense. And certainly that it comes from DOE that we have to do that. But the ABA Council has been doing more listening. That's certainly been noticed. I think it's great that you have a new advisory group that has educators and justices. You're also looking at the standards with a new lens, from what I understand.
Yeah. So, and this has been the main task of the advisory committee to help us develop that lens and to look at our standards. But this effort really started a little more than a year ago when we set about trying to state what are the core principles and values of accreditation. Why is it that we're doing what we're doing in the first place? Why does it matter? What are we trying to achieve? And that turned into, after some deliberations with the council, it turned into a 4-page document that's available on our website. Anybody can go take a look at it, called The Core Principles and Values of Accreditation. And we list there kind of what our core principles are. Among them are the consumer protection piece that you mentioned, to make sure that students who go to a program can be assured that it's high quality and that they're going to get the value for the money that they're paying. It also includes protection of the public, making sure that those students, when they graduate, have a quality education that will enable them to serve the public effectively. So in some ways, that's also consumer protection, but it's consumer protection for the client, right? Not for the student. We also talk about the importance of the changing norms of the legal profession and how accreditation needs to be aimed at protecting those. In addition, after we state our core principles, we go on and talk about sort of the functional values that drive us. So things like transparency and listening to lots of constituencies and making sure that when we're evaluating schools, we're doing so fairly and consistently. So all of those things are outlined in that document. After we achieved that, the thought was, we really should go back and look at our standards and rules and make sure that they are all aligned with the core principles that we've now articulated, so that we can draw a line from any given standard back to at least one core principle. And if we can't, then we really need to question, why is this here? And maybe we should get rid of it. And so that's the project that we've been undertaking since January of this year. And as I said, we're doing it with the advisory committee. So our standards review committee, which is made up of a subset of council members, and the advisory committee meet together at least once a month via Zoom. We also have an in-person meeting coming up in June where we'll tackle some of the harder issues that we're facing. We get advice from them and we deliberate about whether or not the standards are really necessary in light of the core principles that we've articulated.
It's been a while since I read the core principles, but I was optimistic when I read them. And I think one of the takeaways I've had from the dialogues that have been happening is that there's a competency and a minimum standards kind of approach that you're getting back to, as opposed to kind of the best practices that every law school should have to be the most outstanding law school that it can be. So I know that's a hard balance, right? Because some of the things that would be the best things certainly would help the public and would help students, but we also care about cost. We also care about replicability at all law schools nationwide, regardless of resources. So
yeah, broadly speaking, you're correct. And I would just say the devil's in the details there, of course, because that, stating that principle doesn't solve every question. Because then you've got the question, is this really a part of a minimum standard to prepare a lawyer who's competent to practice law? Right. That's the question ultimately. And people can have different views on that, with respect to any given standard. But at least if you've started from that same place, you've got a chance of having a conversation around the right topic. And that's what we're hoping to do. And I think early returns are good because we're having conversations that I think are fleshing out that question in a lot of different contexts more efficiently and more comprehensively than we've done to date.
Well, that's a big job, but I'm glad that you've undertaken it, and that review and pulling it back and making sure that it's coming from the core principles is really important. But moving forward, people might like to know, how the council decides when to have a standard, when to add a standard, what additional things to consider that perhaps were not included in the standards previously. How does the council go about deciding that there's something additional that needs to be addressed?
Well, it's a lot of listening fundamentally, and that happens in a lot of different ways. So there's a formal way. Every year we invite the public or any of our interested parties to submit suggestions for things to put on the agenda of the standards committee. And those can be standards that people think we need to add because there's some problem they see that needs to be addressed, or it can be suggestions for revision of a standard or even repeal of a standard. That happens in May of every year, and the standards committee reviews those submissions, and that helps to generate the agenda that then is presented to the council for adoption in August of every year. And that then shapes the agenda over that particular year. So that's sort of the formal way, but there's also a lot of informal listening, starting with the council's experience with particular schools as they go through the accreditation process. So sometimes we see, for example, a standard that's ambiguous, and we realize after looking at 4 or 5 schools where the same question has come up, and we realize, the questions here are really about the ambiguity of our standard and not about something to do with the law schools. And so sometimes the council itself will identify something like that and put it on the standards committee agenda to try to better clarify what we mean and to make our requirements more clear. And then, there's all the informal communication that we have throughout the year, visiting our affiliates, talking to deans. We have a number of other organizations that we visit with regularly, organizations like the LSAC, NCBE, AALS, the Dean Steering Committee of the AALS, NALP, Access Lex, SALT, CLIA, et cetera, the legal writing directors, I go on and on. And we try to listen and visit with all of those groups, and sometimes they'll bring something to our attention that maybe needs to be changed. So it's a wide variety of different things, and I think the challenge is actually in collecting all of that feedback and then evaluating what's most important. So that's another reason why sort of the core principles and values was an important project. So, really hit pause and say, hey, when we hear about all these different problems out there or things that people think should be changed, how do we evaluate those? How do we rank them? What's most important? What do we discard and what do we focus on? And so we're trying to get more systematic and more thoughtful about that.
Well, it sounds like that's a great place to start with the discernment from all the different groups that you talk to. In full disclosure, I am part of the LSAC board and also part of the Dean Steering Committee, so I've been part of some of these discussions. But it's great that you get feedback from so many affiliate organizations and, of course, from the public. Now I'm going to hit the hot button topic here, and that is Standard 206 addresses diversity and inclusion, and the council, as I understand it, is considering repealing Standard 206. And so can you share with our listeners why it was put in the first place and why it's being considered for repeal?
Well, so starting with a first principle that I think is important, which is that the council has never and will never require law schools to break the law in order to be accredited, right? So that's sort of our baseline. And actually, we apply that in a lot of different contexts, and other standards have been repealed when they put law schools in a position of where they may be violating the law, right? So similarly here, after the SFA decision came out a couple of years ago, and also after the Trump administration and some of the executive orders that came out early last year, they sort of signaled that there's a big question out there about whether diversity efforts in the area of admissions continue to be legal. And so at that time, we didn't, in that uncertain legal environment, we didn't want to put law schools in a position where they would potentially put their accreditation in jeopardy if they were following an interpretation of the law that they thought they had to follow. And so we suspended 206 at that time. Since then, there's been additional guidance from the Department of Education, most recently leading up to a couple of decision letters by the senior department official that spoke to diversity standards that other accreditors had in their standards. And the department said, if you are going to remain a recognized accreditor, it's not enough just to suspend those diversity standards. You actually need to repeal them. And so when that happened, it sort of was a pretty clear signal to us that this is going to be existential, that if we did not repeal 206, that our recognition by the department would be in jeopardy. And then that potentially leads to a lot of chaos and could hurt a lot of law students. So I mentioned the Florida order earlier. The Florida order says we'll recognize graduates from any institution accredited by an agency recognized by the department. If the council lost its recognition by the department, all of a sudden graduates of St. Mary's would not be able to sit for the bar in Florida, right? And that's true of graduates from all over the country, right? Would be in the same position. So that's chaos. That's great harm to the law students. It's ultimately great harm to the public. And so our calculation has been that that's a result that we need to avoid. Now, at the same time, again, we've got the core principles, right? There's, I think, a fair question, and the council has been debating this for a long time, and it's become more clearly in focus recently, which is what you raised, Patty, about are the standards about minimum standards or best practices, right? I could make a lot of good arguments for why making sure you've got a diverse class is a best practice, right? We live in a diverse society. Lawyers need to know how to operate in that diverse society. It's a good thing when they're around a class that is diverse. But is that an accreditation issue? Is it a minimum standard? And I think even people who are great champions of diversity in other contexts can and have concluded that maybe the accreditor is not the right person to be pushing that. So even independent of what the department has done as part of our overall reassessment of the standards, we've been debating that question. And as you mentioned, the council's conclusion, at least tentatively, pending notice and comment, is that we should repeal Standard 206. That'll both allow us to maintain our recognition with the Department of Education, and we hope it will actually allow those who can focus on best practices rather than minimum standards to step into the space and continue to promote diversity in law schools where it's important.
I appreciate your candor and addressing an issue that I know is a lightning rod for some. Certainly, as you've explained it makes sense, especially when the council itself is in the process of re-recognition as the accreditor with the Department of Education. Can you tell us a little bit about the process that you're going through as part of that? Well, not you personally, but the council. And what's the timeline and what happens if Department of Education is like, yeah, we're going to go with somebody else, or we're not going to go with the ABA anymore?
Yeah. Well, sometimes it does feel like it's me personally going through it. I imagine that as chair of the council, I feel a little bit like the dean of a law school going through a site visit. So it's kind of equivalent, the department looking at us the same way we look at schools.
But on a much grander scale, I have to say. So I commend you for being chair in this particular year at this particular time.
Well, thanks. No, it's been an adventure, but a lot of fun. But anyway, the process started probably about a year ago when we were preparing our application for re-recognition. And just like a law school goes through the standards and explains how they comply with everyone, we had to go through all of the department regulations and explain how we are in compliance with each of them and provide supporting documentation. So we did that. We then got some feedback from our staff analyst at the department, and we had the chance to revise our submission and respond to the staff analyst's comments. We submitted our response in February to the staff analyst, and so our application now is with that analyst again, who's preparing a final set of recommendations. Those recommendations will go to a committee that's called NASIKI, and that's an advisory body that's been set up under the Higher Education Act to help advise the department on who they should recognize as an accreditor. That will culminate in a hearing in front of NASIKI where the council leadership will go and actually answer questions from the NASIKI members. That's going to be in September. After that, NASIKI will vote on our application. They will make their own recommendation to the department's senior recognized or senior department official, who is the person designated to decide on these applications by the secretary. That person probably will take a couple months and will come out with a decision, which could be, yes, fully re-recognized. It could be, yes, recognized, but we have a few things that we want you to report back on. Or it could be ultimately, we're choosing not to recognize you. And you asked the question, Patty, what happens if it's the latter? Well, nothing happens immediately. There's a set of appeals that we have the right to take, including first to the secretary and then in court if we needed to. Once those appeal processes have run their course, though, then schools that are accredited have, I think it's 18 months to find another accreditor after that. The question you might have is, well, would the council be out of business at that point? And the answer is definitely not, because of the other reason that I mentioned at the beginning for why we do what we do, the other sort of institutional factor, which is the state Supreme Courts. So each of the state Supreme Courts could continue to recognize graduation from a council-accredited school as making graduates eligible to sit for the bar or to otherwise pursue licensure, right? And we suspect that most states, maybe all of the states, would continue to rely on us at that point. Now, Florida, I mentioned, is the only one that has explicitly said, if you're not recognized by the department, we're not going to rely on your accreditation. I think that even there'd be a question if the Florida Supreme Court would blink. right? Because do they really want to turn away the graduates from Harvard, the graduates from Georgetown, the graduates from Yale, University of Chicago, pick your school, St. Mary's, any others.
I was going to add
Um,
St. Mary's to that robust list you had.
Absolutely. Absolutely. And would Florida be willing to do that, or would they start making a whole bunch of exceptions that might land them, more or less back where they started, which is recognizing graduates of council accredited schools? And so, because of how important portability is, there are strong forces working towards, through the medium term at least, states continuing to rely on the council. And I think as long as we do our job, of continuing to be the gold standard in legal education, accreditation, which is what we are working very hard every day to do, then I think in the long term as well, states won't really have any plausible alternative other than to continue to rely on our work.
So is there a scenario, I mean, you may know this, you may not. I don't know what the Department of Education has done in prior iterations of their reaccreditations, but could it be that the department would say yes to you, but also yes to, the new National Law School Accreditation Association?
They could, yeah. And there's actually some proposed rulemaking out now where the department is trying to simplify the process for new accreditors to get recognized. And frankly, that doesn't scare us. I think it could be a good thing because, again, when you're the gold standard and if you're working hard to stay the gold standard, the existence of other accrediting bodies is not going to ultimately be a threat to that. Now, if we aren't doing what we're supposed to do, then that's a different story, right? But I think we are, and I think we can demonstrate the quality of the council's work product. And that'll only be confirmed more fully if we demonstrate that, alternative accreditors aren't able to easily recreate the quality of the system that we have, right? And, just as an example, there's California has had its own accreditation system for decades now, where they allow students who graduate from state bar accredited schools to take the bar exam in California. Those students, of course, can't go to other states. They can only stay in California. So there's a disadvantage there. But I think that, if there were a way to accredit law schools, much better than the council does, I think it would have been found in places like California. And yet, as of now, bar pass rates, just to take one measure of quality, are 3 times greater in council accredited schools than they are in non-council accredited schools, which are right now almost exclusively California schools. 3 times. So that's a pretty significant difference in quality. And I think it demonstrates the importance of the council process, that we really are a stamp of approval that it is meaningful in the marketplace. And as long as that's true, like I said, state Supreme Courts will have a strong reason to continue to rely on us, even if there are other accreditors out there that are trying to, eat around the edges like California and accredit some additional schools on the margins.
Well, that's good to hear that those are your thoughts, because I do get very concerned when I look at things like the bar passage in California among unaccredited schools, un-ABA accredited schools, really stark, the difference in results. And that's frightening for students who undertake that kind of debt and time and energy to get those law degrees if they can't end up passing the bar and getting employed. So we've talked about if the council... Well, we didn't talk about if the council is unaccredited very much, other than you all would handle it through appeals, and that wouldn't be it. There'd be an appeal within the system and maybe litigation. So it sounds like we are probably years away from an impact of the decision that may come at the end of 26 and 27, no matter what DOE decides.
Well, I think that's true. We fully expect that they'll re-recognize us. We've worked very hard on our application, answered all the questions that they had for us at the first round of review. So, I fully expect that we will be re-recognized. If there were some reason so that could be the end of it. Let me say, if we're re-recognized, then we're good to go for another 5 years. If we're not re-recognized, then there's the appeal process. And then, like I said, there's the practical question of, would the state Supreme Courts change the way that they regulate admission to the bar? And like I said, even there, I've talked to a number of state Supreme Court justices about this, and many of them say, well, department recognition really isn't important for our purposes. We're focused on which accreditor is going to help us determine which graduates of law schools are capable of providing quality legal services to the public, right? That is what they care about as state Supreme Courts. And as long as we're doing that, again, we can keep doing what we're doing, even without the department recognition. In fact, that just moves us back to the pre-1952 period, when we did this for about 30 years without department recognition. Parentheses, it didn't exist at that time, right? Because the department wasn't doing what it's doing. But the system developed entirely outside of the Department of Education's purview until the 1950s, when they started paying attention to what accreditors were doing.
So before I wrap up with the question I always give to my guests about legal education in the future, I want to give you you an opportunity to explain to our listeners the distinction between the American Bar Association, the big behemoth that, many lawyers belong to, and the council.
Yeah, and I noticed I've been saying council accredited, and it's throughout the interview, and the point of that is to highlight that distinction, and it is significant. The origin of the distinction comes from the Department of Education again. It's part of their regulations for accreditors, and their regulations say that if you are an affiliated professional organization that is affiliated with an accreditor, that is, that the accreditor has to be, quote, separate and independent from the organization. And that's defined in the statute as to what that means. So we have to have a separate budget, right? Number one. And we do. The ABA does not send the council any money. We don't send them any money. And we develop our own budget every year. We decide what to spend money on. They don't have control over it. Number two is that the selection of personnel on the council, so the members and the officers, cannot be done by the bigger association. And again, that's true. In our case, we've got an internal nominating committee and election by the membership of the section. The broader American Bar Association doesn't have any say in who's chair or who gets to be on the council. So we check that box as well. And then the third would be independent policymaking. So the American Bar Association does not have any say with respect to individual school decisions. Those are entirely handled at the council level. And with respect to the question of what the standards should be, the American Bar Association House of Delegates only has an ability to give advice about that. So we go to the House of Delegates with proposed changes to the standards, and they get to weigh in, but then the council makes the final decision on what happens. So in all three of those areas, we are separate and independent from the larger American Bar Association.
And did I read that there's movement afoot to make that distinction even more legally recognized?
Yeah, so this might qualify as sort of inside baseball, but for for your listeners, maybe they care about the inside baseball. We've got a set of bylaws changes that we proposed. They've been passed by the ABA Board of Governors that had to sign off on them. And what we've done is essentially take one set of bylaws for the section, and we've divided them into two. So we've got one set of bylaws that is just about the accreditation function. And it is entirely separate now from the larger ABA processes. That set of bylaws is entirely under control of the council. American Bar Association has no say. And then we made a separate set of bylaws that addresses what we call the other section functions. So like if we want to organize a CLE with the litigation section, we can do that just like any section of the ABA can do. Previously, that's been all under one set of bylaws and one set of officers. Going forward, it's going to be completely separate with two sets of bylaws, eventually two governing boards. And we think that'll just help clarify and sharpen the distinction even more than it already has been.
Excellent. Well, one thing I have appreciated, even though, every 10 years when we have to go through that questionnaire, it is a bear. There's no question. And it takes tremendous effort. But what's great about it is the resultant data that you all get from each of us. And those 509 reports, I think they're just tremendously helpful to applicants when deciding what law school to go to. And frankly, I think they're super helpful to us who are at law schools to see where we are in the marketplace and what we might aspire towards. So that I think is really a great function of the section. So my last question is, what are your predictions for the future of legal education in the coming decade? This one should be easy compared to all the others.
Well, and I guess on this one, I'm speaking more for myself and less for the council because, kind of speculating about the future. It is fun. But, and I've been thinking some about particularly how AI is influencing legal education. Lots of people have been thinking about that. And the way I break it down is to say that actually legal education is really well set up for the world that we're driving into, where AI is more prominent, more a part of legal practice. And if you think about it, what do lawyers provide to their clients ultimately? You can kind of divide it into three buckets. There's knowledge, right? Just what is the law? What do the statutes say? What do the cases say? So that's number one. Of course, ever since Google came along, that's been much more available to the public than it's not exclusive to lawyers. Number two is the technical ability. Can you draft a complaint? Can you draft a brief? Can you write a contract? Can you negotiate, et cetera? That one too, technology now with AI is more and more able to do some of that. But the third thing that I think is super important for lawyers, it's really our superpower, is judgment or wisdom, right? How do you synthesize all of the knowledge you have? How do you use it with your technical abilities? But then what decisions are you ultimately making? And lawyers provide that service to their clients in spades. That's really ultimately why we get hired, I think. And that is not going to be turned over to technology anytime soon. So ultimately, I think law practice is going that direction where there'll be even more of a premium on the judgment and wisdom because the knowledge and the technical skills will be picked up more and more by technology. And so the question is, what about legal education? Are we educating folks the right way for that world? And here I'm very hopeful because, if you think about the case method, which is kind of the bedrock of law school, it shapes the first year curriculum, right? It's really designed to give students exposure to lots of different practical situations so they can see how wisdom and judgment were exercised in those situations. And that's a great foundation for developing wisdom and judgment, right? And the Socratic method in a 1L class, I think, is really helping students to develop that faculty. Now, it's true the case method has originally been much more focused on the theoretical questions, what should the law be and what rules apply here, rather than on the practical questions, like how would you advise your client in order to actually solve this problem? But the method's the same, and I think law schools are doing a good job of kind of using it not only for the theoretical, but also for the practical. And so that, that speaks to the development of clinical legal education. You were a clinician, right, Patty, yourself?
I'm a big
Yeah, the clinical legal education movement, I would say, has now come of age, and it's doing a wonderful job of developing that practical wisdom in the context of representing live clients, which, that is the best training ground for developing wisdom and judgment among students. And I don't know how you feel about this, but I think when you say practical legal education, sometimes people hear something different than what I mean, at least, right? Because they hear, learn where the courthouse is, learn how to format a complaint, right? Learn how to use e-filing, right? Those sorts of practical skills, which those really aren't the practical wisdom, practical judgment skills. Those are the technical things, right? Which even your paralegals know how to do. But I think the real benefit of practical education is not to learn where the courthouse is. It's to help develop your ability to make a judgment in the context of a real person's problems, right? When the decision really matters. And so I'm optimistic that, law school now has 50 years of experience of doing that in clinical legal education. We've expanded beyond that. We have great externship programs. We have more and more simulations. And we're incorporating more and more of the insights of that kind of learning back into the first year, back into the theoretical learning that we're doing. And so, like I said, I think that is exactly what we need to do to address AI and to make sure that students are trained for practicing lawyers in the future. So I'm optimistic.
Well, I'm glad to hear it. And I think you're right. Our superpower is judgment. And there's no better way to have students develop judgment than through clinics, in my opinion. But appreciate your time, really appreciate your insight. And as I said before, your candor. Our guest today was Daniel Thies, the chair of the Council of the American Bar Association section of Legal Education and Admissions to the Bar. I wish you luck because this is a challenging time to chair the council just because of the scrutiny that is out there right now. But good luck. Thank you for your time. And if you want to listen to additional thought leaders in legal education, you can find additional Aspen Leading Edge podcasts on your favorite podcast channels or on the Aspen Leading Edge podcast webpage. Thank you.
And thank you, Patty. It's been great to be here, and I really appreciate the opportunity to speak with you and your listeners.